Welcome to the Wake Forest Journal of Business and Intellectual Property Law's 2021 Symposium, which we've titled Preparing for Disaster. I'm Andrew Bosserman, the editor-in-chief, and I'm excited for you to join us for many great discussions surrounding the COVID-19 pandemic and how businesses and individuals can best prepare for the next pandemic or whatever disaster that may be. This video will feature a wide-ranging discussion surrounding business and intellectual property law with three practicing attorneys. Our first panelist is Michael Boyer with Carolina Craft Legal. Michael focuses his practice on North Carolina alcoholic beverage law and provides innovative legal solutions for our state's many entrepreneurs and startups. The second panelist is Stephen Hallman with Shepherd Mullen in Washington, D.C. Stephen is a partner in the Business Trial Practice Group and is also the leader of the Trade Secrets team. And our final panelist today is Stephen Kong with Troutman Pepper in California. Stephen focuses his practice on technology and intellectual property transactions, which include licensing, development, commercialization, and transfers of ownership. Moderating the panel today are the journal's very own Maurice Goldston and Liz Pomeroy. Two quick notes before the panel begins. First, if you're interested in supporting the journal, the best way to do so is to become a print subscriber. If you're interested in learning more about how to subscribe to our print issues of the journal, please click the subscribe link above at the top of this webpage. Also, the journal is always looking for great legal scholarship to publish that involves issues of business and intellectual property law. If you have a piece you'd like us to consider for publication, please click the submissions link above. Thank you again for watching and supporting the journal. Enjoy the symposium.
All right, well, welcome to this discussion, and thank you all for being here. I really appreciate your time and all your preparation for this event, and I think we're having a great discussion. So I guess just to start off with, who are your clients?
I guess I'll go ahead and start. I have a split practice. I spend a good portion of my time being the IP lawyer for private equity funds making acquisitions. So that's a big part of what I do. Private equity, what they call sponsors, basically buy companies or buy controlling stakes, not necessarily controlling, but they're investors essentially. Sometimes they buy companies outright. Sometimes they make investments, and I advise on the intellectual property aspects of companies, of funds investing in companies. I also represent companies, operating companies, in their intellectual property needs, but with a special kind of intellectual property. I focus on acquiring intellectual property rights, commercializing intellectual property rights. I get involved in any sort of transactions involving the exploitation of intellectual property. So I don't write patents, but I'm involved in agreements that license them or help develop the technology that leads to patents being written. Okay, that's me.
Thank you.
I'm happy to go. I represent a lot of clients in the pharma, food, and beverage dispute area. Pharma, obviously, be involved in representing bringing to market pharmaceutical products, and I'm on the branded side. Typically do not represent generics. Also represent medical device companies like dental laser devices or ventilator devices, and tech companies, particularly in trade secret disputes. For patents, display companies, broadcast companies, chip manufacturers. That's a good range.
And my clients are typically in the beverage alcohol field on the supplier side. most notably in the beer sector. So I'm on the front end transactional sort of brand forging end of things. And as the companies tend to develop, my relationship with the company grows proportionally. And as the distribution footprint expands and their relationship with their consumers grows stronger, heavily involved in developing brand guidelines, helping avoid potential pitfalls and issues out in the marketplace, in particular respect to the craft beer industry now with more than 8,000 licensed breweries in the United States, in a very small vernacular that's shared between them. You can imagine that that becomes a bit of a philosophical debate internally about what it means to really forge an identity while also speaking a familiar language to a broad customer base. So really involves soup to nuts and understanding what a client's product is, what their underlying values are, and ultimately what their goals are long term, and attempting to preserve those and mitigate disputes.
I guess my next question is, in the circumstances we're in now, what was, in the COVID pandemic, what was the first thing that you thought of with your clients? And did you think, wow, this is something I have to address right now? Who did you go to?
Well, I'll go ahead and maybe give a slightly broader answer. My firm, like many law firms, created a COVID-19 task force. So, and I was asked to be on it. Our COVID-19 task force was fairly large. So for me, of course, I was asked to focus on commercial contract issues. And, you know, there were a lot of different angles for what clients would need. So if you look on, you know, really just about any of the large law firms' websites and look at what their COVID-19 task force where you would see that there's employment lawyers involved, there's corporate lawyers, lending lawyers. You know, if you represent a retail client base and you're concerned that, hey, we may have to shut down for some period of time, what should we try and get about lines of credit? Real estate lawyers, you know, were on this COVID-19 task force, obviously, both from the tenant side. You know, you've got tenants who basically are saying, do I have to pay rent or I can't pay rent? You've got landlords saying, can I collect rent? I mean, everything. I'm not going to try and run through every issue, but I will say this, you know, the first thing we thought is as a firm, we organized a group and we said, okay, listen, what is it that we think clients are going to need? I mean, it turns out it was a fair amount. My firm actually happens to have a very large health sciences practice. So, you know, right away, there were issues about which of our clients might be involved with either COVID-19 treatment, diagnosis, things like that. And so I think, you know, speaking for my firm, the first thing we tried to do is we tried to formulate a team to sort of try and anticipate what issues would be. We tried to get resources out onto our website. We tried to get resources out to our clients, trying to anticipate what is it that they might need from us. You know, it kind of got to the point. I mean, there's of the three panelists that are here, Steve is also at a big firm. I'd be curious to get his take, because frankly, some of the feedback I think we were starting to get from some of our clients was, hey, whoa, too much. you private law firms are a little too on top of this almost. I mean, we appreciate it in a sense, but like it was almost too much, you know?
So we were asking a question. Well, we had sort of the same reaction institutionally, which is, you know, let's get a COVID task force together and provide useful information to our clients and the legal community about developments that are impacted by COVID, developments in the law particularly. And for me, one question we often get asked by pharma and biotech companies is, what type of protection should I use in order to protect creative developments in my field? Should I rely on patent protection or should I rely on trade secret protection? And of course, the patent landscape for pharma companies has changed significantly since the Supreme Court's decision in 2013 in the Marriott case, which held that isolated DNA segments are not patentable subject matter because they're naturally occurring phenomena. So that caused some pharma companies to move away from seeking patent protection to trade secret protection. Of course, when you have a patent, the quid pro quo for your patent monopoly is disclosure, public disclosure of the invention. And when you're relying on trade secrets, the quid pro quo to getting trade secret protection is that you keep it secret. So no disclosure at all to the public. You have to keep it secret. And so the question is, what policy is best for incentivizing and stimulating rapid, effective vaccine development to address COVID? And is that a policy that promotes sharing of information, or one that protects monetary incentives so that companies can recover their invested capital in research and development and profit from the invention? And so, our first question was, well, what do policymakers think about where that balance should be? And so what we did is we sort of went to the policymakers. We went to HHS and NIH and Centers for Disease Control and the FDA and the White House Office of Science and Technology, the COVID Task Force, and we asked, okay, there's this vigorous debate that's going on out there. What's the best public policy? What do you think? And it was hard to get a straight answer. There continues to be a big debate. I think there was a piece in, I think it was Law 360 the other day, that the U.S. Chamber of Commerce is urging the World Trade Organization not to entertain the thought of granting vaccine waivers for IP protection. And at least two countries, India and South Africa, are sort of leading the way in advocating to waive those intellectual property provisions. And so the same policy question, which is going to incentivize development most quickly so we can get the vaccine out there? And it sometimes it seems like the easy public policy answer is, of course, share the information or don't make it subject to patent protection. But in the long term, are you stifling inventiveness by doing that and by undercutting the incentives that cause pharma companies and biotech companies to be willing to devote the research and development time to creating inventions in this area?
And I love Mr. Kong's answer. Your client's telling you, "Hey, you're doing too much." My answer is much more lowbrow than that, because it was very much more of an intuitive analysis, right? And in my industry, there was a very serious threat to continued viability, because the way the beer industry had shifted in the 5 years prior to COVID was very on-premise, consumer driven. And being in California, you likely know, California has a ton of small breweries, microbreweries, craft breweries. The lifeblood of those businesses is the tap room on-premise environment. It is literally the exchange of money for a beer on site. And that business model proved for the years prior to be a very profitable one, and a very sustainable one. When the COVID restrictions state to state began coming down, that business model was under major duress and was under an existential threat. And because of that, the main question was, well, how do we navigate, if at all? And if the shift has to be to off-premise, how do we legally and compliantly get our products to our consumers, either directly via delivery or negotiate deals with wholesalers? And even if that's an opportunity, what of the products that we've just been slinging to our customers over the bar that maybe we see as a flagship or was a consistent product that we produced, do we have room in the market that we're going to be able to push this out to customers and not infringe on the rights of other more established brands that are currently there? And so really that was sort of a matrix that revealed itself to us on a client by client case, really based on the scope of their current operations at the time that COVID hit, and really their ability to pivot and procure new resources in terms of aluminum, canning lines, bottling lines, flexing wholesale relationships, whether the law allowed for self-distribution, whether whether the administrative agency was going to create certain carve-outs to encourage delivery and direct-to-consumer opportunities, and within all of that, how do you safely and effectively manage your relationship between your employees and your production staff, as well as those relationships you have with your customers if you're going to be stepping onto their doorstep or encouraging them to come to your place of business just to pick it up. So there wasn't very much that was obvious at the beginning, but it was a very needs-driven analysis, right? Client by client based on their size. And again, that's why I call it very lowbrow, because our client base doesn't span the Fortune 100. It is very much Main Street. And for those that are fortunate enough to get to a place where they're beginning to scale, it wasn't as arduous of a journey, and our conversations were much more dynamic and ambitious than those who are, on a side street in a small town that's undergoing some sort of local revitalization, right? And maintaining some level of visibility to the customer became an issue as well. So much more in an advisory capacity business-wise than I would say intellectual property. Intellectual property was sort of a de facto analysis to the extent we stumbled upon some gold in terms of the way packaging or a brand came about during that madness.
Going off of some of your answers here, my next question is, how does the size of the client affect your analysis of a legal matter in crisis, right? So I guess, if in your experience, has there been one common disaster that you've advised a larger client with more resources versus a smaller client? And how does that process differ? And this is to the entire panel.
1,000%. So the biggest of our beverage clients were able to make positions from, I think, a position of strength before governments were enforcing top-down executive action to close down on-site operations. Here in North Carolina, it was the weekend before St. Patrick's Day when these businesses were really trying to usher people into their doors and make that last bit of money before the authorities were going to close things down. The larger of my clients were the ones who were having proactive conversations about, was it socially responsible to be trying to make those dollars right there before the incoming lockdown, and what does that mean for the future of their business and their brand? So for the larger ones, and when I say large, we're not talking about a Sam Adams or a Yuengling. We're talking about those that sort of revolve in, I would say, a Wicked Weed-esque tier, where it's tens of thousands of barrels, not hundreds of thousands or millions of barrels of beer. And it just meant that if you're able to make a decision to protect your employees, to treat the community as a stakeholder, that you do so. And to the best of our ability, we would take crisis and manage it in a way that gave some goodwill back to your company through the course of COVID. So that's, I think, the long and short of it on my end. The smaller ones, of course, we're going to take every allowable inch up until the point, because they did not have the off-premise and wholesale network to lean into, right? And that's just a resource-driven analysis.
So sort of echoing some of those themes, I would say the smaller companies typically just want the problem that's confronting them now resolved. And the larger companies, especially those with in-house counsel, those in-house attorneys are thinking proactively and philosophically, what's my legal spend going to be on this issue? Is it likely to be a recurring issue? What can we do systemically and institutionally to prevent this problem from occurring again. And so, if you want lawyers advising you on those things, then the lawyers are doing a more systematic review of how the problem originated and how it can be avoided in the future, versus just litigating the issue in front of you.
So the changes that you all made in your businesses and with your clients, how do you see those either staying or changing if and when COVID ever ends, kind of in the long term? Do you think those are just very temporary, or do you think those are things that you'll implement in your relationships with clients or in your business further in the future?
So I think for us, go ahead, Steve.
Oh, no, you go ahead.
We've moved to an online platform for much of the work that I do, and for much of the connection I have with my team in the DC office at Sheppard Mullin. There's a lot of attractiveness in being able to practice from a remote location and not need to fly down to see a client, but having that interface by Zoom or Microsoft Teams or whatever platform you're using. My firm philosophically believes really strongly in the positive effect of everyday human interaction. So I think the remote office way of conducting business that we practiced during the pandemic will retreat, and we'll go back to principally an in-office firm. I think also from a trial lawyer perspective, a Zoom deposition has nothing on an in-person deposition where I'm sitting across from and eyeballing the witness and asking the questions and getting the answers and assessing credibility. And the same is true at trial. I just don't feel like I can do those things as effectively. And even making eye contact with a three-member panel of appellate judges, I don't feel like I have the same interaction, the same quality of interaction by Zoom that I would have if I were there in person. And so I'm very much looking forward to going back to an in-person, show up in the courtroom type litigation practice.
Yeah, I was just going to say that my firm feels similarly, that we are not going to be a remote law firm, and that we value the ability to meet with clients in person, certainly from time to time. And we have already been told to prepare ourselves psychologically for returning to the office. Whether we will all be expected to be in the office 5 days a week, I'm not so sure. I'm not so sure that was the case even before COVID. Frankly, I think this is a good environment for talking about this, because obviously there are law students listening in right now. I think that there was always pressure for the more junior lawyers to be physically in the office more than, say, the partners. I think that was true before COVID, and I think that's made sense for a lot of practical reasons. The one feedback I think that we have gotten is that the fully remote working environment has actually been hardest on the more junior lawyers. They benefited in the past from physical proximity to other lawyers, so that there was an easier way for them to walk down the hall and ask another associate, hey, have you seen this before? Man, that partner's an idiot. He asked me to do this. What the hell was he really asking? Things like that. Look, in theory, you could sort of email your buddy to ask, but not really. You know what I mean? Nothing really is the same as just being able to do it very informally. And so I think from a working environment standpoint, return to the office would actually be most beneficial really for the more junior lawyers.
And I think, my experience is unique on this panel, and probably unique in the context of the larger picture for lawyers. I started my practice in late 2015, and it's been virtual from day one. I have a partner who anchors our practice in Charlotte. I'm here in Greensboro. And from day one, we were sort of a work from home, WAFH acronym style firm. And that was as a tool to be able to flexibly create relationships with clients whose resources did not typically include on the front end business plan legal advice or legal counsel or that element of sophistication to paper deals, to help with financing, to procure real estate, to navigate the regulatory process with the TTB or the state level agencies. And we found a niche within that, being able to lower our overhead and meet the client where they were. And that became something of a comfort level for us and for the clients. And we spent whatever money we were spending on office spaces and additional infrastructure, traveling and being on site when and where we needed to be, which created and cultivated a more dynamic relationship and higher trust relationship with those early clients. So COVID, for all of its faults for us, has not posed any real challenges in our workflow, in our communication, our delivery mechanisms. That's the cloth we were cut from. If anything, I think it has helped to give our clients an even better a better view into how productive they might be internally from in a remote capacity. And some of those have certainly recognized that the physical proximity just has certain inherent benefits. Others have in terms of you can't produce beer from home, right? But in terms of the back office and the marketing and sort of the executive leadership, you don't necessarily need everybody to be in the one location where your product is being made and packaged. You can safely transact business and make things happen from afar. And we've been able to lean into that and sort of run that race with them.
So, and I would just say in response to that COVID has sort of broadened the sense that concept has been proven successful, and it will be an increasingly important segment of the market for lawyers like Michael, who have demonstrated that they can reduce overhead costs and provide an affordable service to clients that some of the larger firms have priced themselves out of the market to be able to provide. So I'd say that's an increasingly important market segment.
Well, it also invites the conversation around fee structure in a more meaningful sense, right? The billable hour is still king and will remain king for a while, but what we've been able to do is really tailor our services to the unique needs of each client. And those who love a more traditional relationship with their attorney, we bill hourly. Those who are more ambitious or aggressive with the way that they want to predict their costs and expenses, or want a closer relationship with us in a more advisory capacity, it just shifts our priority and how we create our workflows around that. So definitely, I think to your point, Steve, it's that'll only increase industry-wide.
In times of crisis, or just think of a time in which your practice has been put through a time of crisis or a disaster, I guess what big vulnerability in your discipline have you seen, and do they still exist? Like, were they exposed, or do you think that, and what do you do about it? After you've noticed it, did you morph your practice, right? Or did you sort of speak up and say, I think this is a huge gaping hole? How'd you respond?
Well, I'll bring up something that, unfortunately, I think only Steve Holman's actually going to really be able to relate to. So Steve Holman and I were both intellectual property lawyers. The last big crisis people thought was going to occur was in the year 2000. People thought that computers were going to be going haywire over the Y2K. Now, I don't even know if you guys age even know what I'm talking about, but it really was actually a big deal. And all this stuff about the COVID-19 task force and all that, obviously this Y2K issue was not as big nationally, but law firms did set up these Y2K task forces, and people were not sure, like at the stroke of midnight, whether, I don't know, like entire power grids were going to shut down. I mean, I'm not kidding. People were speculating about stuff like this. And of course it didn't happen. And that's a long way of saying, ironically, I'm on my firm's COVID-19 task force focused on commercial contracting. And I hate to say it, but actually we have not seen nearly as many changes during this COVID-19 task force in the world of commercial contracting as we thought. Now, I will tell you what we speculated we were going to see. We speculated that there was going to be this big need to overhaul force majeure clauses in contracts. So if you took contracts class, I don't know if you remember the concepts of like commercial frustration and things like that. It's all kind of related, right? Is there going to be a defense on the part of the party that was supposed to perform under the contract that they couldn't because of COVID-19? And, the reality is, I think that that's actually always a defense. And so I'm not sure that it's easy to kind of draft around, but there was some thought. I know I worked on one it was one development deal that occurred in the summer. And of course, when COVID-19 was really, it still is at the forefront of people's minds, but it really was. And there was this concern that our client was going to be the recipient of some services, where was the service provider going to be able to just say, well, I couldn't perform. This service provider was in a foreign country. That added just a little bit of complexity to it, because, who's to say that maybe in some countries they weren't just going to, I don't know, some national orders, factories shut down or something, who knows? And, the reality, unfortunately, is we haven't really seen, we thought there was actually going to be a big push at one point that big companies were going to go in and try to negotiate changes to force majeure clauses to either, if there was a force majeure clause at all, basically say, well, COVID-19 is not an exception. Despite COVID-19, you still have to perform. Now, the hard part about that, of course, boy, I can't believe how much first-year contracts actually matters. You have this issue about whether there's consideration. Can you get the service provider now to agree that they still have to perform, and if so, what's the consideration for them to agreeing to that, et cetera, et cetera. We actually have not really seen that occur. I don't know if it's because there hasn't been as much inability to deliver as we thought. I'm actually not 100% sure what the answer is, other than we have not seen this big push for like major corporations to go out and hire armies of lawyers to go out and renegotiate existing commercial service agreements.
So thinking about how this has affected the legal market, courts are shut down. So as far as having trials or in-person motions, that's just, for most of the country, it's not happening at all. For a few places, it's happening a little or sporadically. But in the meantime, there's this huge backlog of cases that can't progress beyond a certain point because there's just no getting on a trial calendar yet. And from my perspective, it sort of highlights a significant change in the legal market for litigators since I started practice many years ago. Back in my early days as an associate, it was considered to be a very good thing for an associate to be broad-minded and to be able to handle any kind of civil litigation matter that came in the door. And now the market has changed significantly, especially in big law, towards specialization. And so as an associate, you come in, you get slotted very quickly into a practice area, and then you get expected to develop a specific expertise within that practice area. And, if something happens in the market that hurts or negatively impacts that practice area, you're sort of stuck and there's not too much to do. But if you came up as more of a general practitioner and understanding the importance of providing counseling and guidance as well as litigation assistance, then there's almost always something to do, even though cases aren't moving in court. So To me, it highlights the benefits of being a generalist. And so I would say to young lawyers, resist the urge to specialize early.
I'll tell you though, the one issue with that, I hear what you're saying, Steve, and everything's relative. Like by maybe today's definitions, I'm relatively a generalist within the field of technology transactions, IP transactions. I'm not nearly as specialized as some people, but but I'm not a generalist either in the sense that I certainly don't litigate. I mean, there are transactional lawyers that even litigate a little bit on the side, and they do some transactional work also and things like that. I think the dilemma that young lawyers are going to face, part of the reason I think that they get pushed into specialization so much, especially if they go to a quote big firm, whatever your idea of a big firm is, but is that the billing rates are so high. The salaries are so high, so the billing rates are so high. And if the billing rates are going to be so high, then the client wants you to be able to do certain things fairly quickly. And the only way for a young lawyer to be able to do some things fairly quickly, I think, is if that universe of things they can do is relatively small. So it is a real dilemma. I don't know what the answer is, but I mean, just to put it in perspective, I think that at a large law firm on the East Coast or on the West Coast, or maybe in some of the big cities, a first-year lawyer today bills out at over $400 an hour. A first-year lawyer, straight out of law school. Maybe three something, but it's if you're at a big firm, a first-year lawyer. Now that's a lot of money. That is a lot of money. You can find experienced lawyers at smaller firms who are billing out at something not much more than that. And so I'm not quite sure what the answer is, but it's, I mean, I think you're right, Steve. I mean, it behooves younger lawyers to try to not be pigeonholed, but it's hard to get paid those big salaries and not be expected to specialize fairly quickly.
So that's the big debate, is specializing versus being a generalist. And my answer to Stephen's comments is the important things to succeed as a litigator are understanding narrative building, storytelling, and game theory. And if you're good at those skills and you acquire strategic judgment, which is experiential, then you can be a good litigator whether or not you specialize. So it's more important to acquire those other skills and to be expert in those areas to be a good litigator than it is to have subject matter expertise, which if you're smart can always be learned.
I agree with one thing though. I think well, I don't want to say you have to acknowledge it. I hope you acknowledge it. I think it's a little easier to be a generalist in litigation. It's a little bit easier because you have a little bit more time to get your hands around facts. The nature of litigation tends to be that, by the time it comes to the lawyer, you generally have an idea of what the dispute is. Transactional lawyers, it's a little bit tougher. In this sense, it's tougher in this sense. We don't quite know what can go wrong. I mean, we have maybe a general idea, but when we're working on a transaction, nothing's gone wrong yet, right? Our whole goal is to prevent it from ever getting into the hands of a litigator, frankly. I mean, that's my whole job, is you better hope this never gets to litigation. So in order to do good transactional work, well, I mean, look, I've been a lawyer for 20 something years, and I do transactional work within this space. I don't try to do a securities document. I don't try to do a banking document. I don't try to do, an employment agreement. I mean, I do it within this space. And I think it's taken me a lot of years just to get decently, good at that space. But you're right. It's true. Litigators, I mean, litigators can litigate against a very broad spectrum, even outside of intellectual property. I mean, they can do a commercial case, they can do a breach of contract case. So yeah, in that sense, I think that really just reflects a real difference between the nature of litigation and the nature of transactional work.
Well, stepping a little bit further away from the legal field specifically, I think the only the crisis I could lean into the most is access to new markets for the clients that are going across state lines in a highly regulated field, such as beverage alcohol, because as you know, state to state, the regulations and the entry points are disparate, right? There isn't one unified body that governs all of that, aside from the TTB granting you sort of that gatekeeping access to commercial activity. What we saw with COVID was state to state regulatory agencies were sending people home. So at the exact point when on-premise businesses needed access to new markets, even if it was sort of here at home or just across state lines, let's say in North Carolina, access to South Carolina or Virginia or maybe Tennessee or Georgia, you have all of those state agencies who have really slowed down their funnel of new work and being able to process applications and bring new people into market. And because of that, some of the smaller clients had to wait even longer while processing perhaps PPP loans, et cetera, in order to gain access to new markets. And I guess I can call that a bit of a crisis, just because it created a bit of a perfect storm, right? So your primary business model starts to falter, and then at the moment you need to lean into a more diversified model, you don't have access to new markets.
I guess, Mike, specifically to you, I guess brewery law and small business law is sort of a small field that not many people know about. But what I guess discrete harm has your businesses faced that maybe the public might not be aware about, or maybe like how a disaster like a hurricane, or maybe even one in recent memory, has affected the brewery space differently than maybe other small businesses or other sectors that people are aware of?
I think COVID is a perfect example of very specific harm, because I treat social media as sort of a crisis and wait at all times. And you have very polarized opinions on all sides of the issues. And when you get to this paradigm of sovereignty versus, top-down control, and how people should be behaving and what risks they should be tolerating versus averting, and you have a consumer base that is sort of circling around one product, you always have to do a tap dance around how you're treating your business, the way that you're marketing, and I think even closer to the operation itself, when you are responsible for putting a food product, right? Beer is considered food. When you're putting a food product into commerce, you have to isolate as best you can those people who are responsible for bringing those products into packaging, into kegs, et cetera, putting them into pallets, putting them onto the back of trucks, or either delivering them into the market. And to the extent you have, COVID scares, or you've been in close contact with somebody who tests positive and you have to quarantine for a 2 or 3 week period, larger companies can absorb that in a relatively easy way, right? You can shift and flex schedules around a little bit. But by and large, when you're a smaller operation, fewer employees, obviously the proportion of responsibility is larger with each person, an individual within the organization. And when you're trying to stick to a timeline or really create throughput that's meaningful and vital, certainly at this point, you have to be even more careful with the way that you operate and what you allow your employees to expose themselves to on a day-to-day basis, and really create an environment of high trust, which is quite difficult, right? Because again, I said social media is sort of a crisis and wait, but every individual has their own varying degrees of risk tolerance or aversion. And it's not really until the point at which it becomes a problem that that's completely visible. So you learn a lot about your team and your culture as a company through things like that. But I think that COVID has been, the most acute example of a crisis that has spidered in an industry that I've known yet, right? Both externally from customer expectations and the disparate nature of that and how vitriolic it can get, and then internally about how much you need to trust that your employees are doing the right thing in the right spots.
What are some of the best and worst responses that you've seen to a disaster in your chosen field? Like, is there a model of excellence or a model of don't do this? And this is to the entire panel.
The model of doing it right is to, one, be upfront and get out front. So if it's like a major data breach, get on top of the problem as quickly as possible and then get the message out to your affected consumers about how their personal information has been compromised and what you're going to do about it. Or if it's if it's a food company that's branded as natural or organic, and some information comes out that suggests that their source of supply isn't actually natural or organic, get out front of that. Tell the consumers what happened here and what you're going to do to correct it and to ensure that the brand promise you're making to them is being upheld and that you are true to your brand values. Those are the most important aspects of responding to crisis.
Kind of on the topic of getting out front of something, when you're reflecting back on the past year and how you've handled the transition to virtual, how you've handled relationships with clients, if you were to ever have to go through another crisis like COVID or some sort of, I don't even want to think of what, but how would you change the interactions that you've had over the past year? Or how would you recommend to your company to change what they've done based on how they've handled this past year?
I think from my perspective, what my firm has done successfully is to appreciate that contact with your clients is very important. And so checking in on a regular basis, asking them how they've been affected and how you can be helpful is appreciated by most of our clients. And being available, thinking ahead of the types of problems they're going to be confronting and being prepared to deal with those. Those are successful strategies for dealing with clients during a crisis.
I just want to echo what you just said, Steve. I think that's spot on, 100%.
My firm actually underwent a merger in the middle of COVID. I was actually a partner at Pepper Hamilton, which is a large Philadelphia firm. I mean, I was out in the Los Angeles office. And I can't believe we pulled this merger off. I mean, I really can't. And it was, I can't imagine more difficult circumstance. I mean, these are not small law firms. I mean, Pepper Hamilton was 400 plus lawyers. Troutman Sanders in Atlanta was 600 plus lawyers. And, I think in general, we did it all correctly. I think the one thing, well, I'll tell you what in my personal opinion, has not worked that great, but I think that this is going to depend a lot on the individual psychology of people. We had a merger that we were going through. And, the thing that makes a merger most successful in a law firm is not integrating the accounting systems or getting it all under one website or things like that. It's really the personal integration. The thing that makes two law firms coming together work is the ability for each law firm to provide its clients with work or with services, advice, work, experience that they couldn't have provided but for having their new colleagues. And the only way that you can really do that is for colleagues to get to know each other. And that's been very, very difficult during COVID. We did try to do some Zoom social events. I think that it is tough. I think that, I think Zoom's great. I think Zoom is great for one-on-one. I think Zoom's great for stuff like this. I think it works. But for informal socializing and getting to know people, I think Zoom feels forced, in my opinion. I'm not sure what the alternative though is for COVID. So I'm just like most lawyers. I'm pretty good at spotting issues. I'm not always good at spotting answers, but so I'd be curious what people think, is the alternative really.
Yeah, I would only fold into that analysis that I think it's the same with maintaining and developing client relationships, right? I think the biggest opportunity that has been presented to us out of COVID is the opportunity to reinforce to the client that they are the main event. but you have to be a little more creative with the way that you're conveying that. Like you said, Zoom calls, no amount of Zoom calls or Google Hangouts are going to do the trick. So you really do have to figure out more intuitive ways and more familiar ways to kind of to be present, to maybe see around corners and issue spot, and really maybe just take the conversations outside the confines of some sort of abstract legal issue or some sort of time sensitive or outcome driven initiative, and just talk to people and see where they're at. A lot of the smaller businesses that I work with, they're still dealing with the toils of the day-to-day, right? They invest all of themselves into operating a business, but they still have a wife, they still have children, they still have to run school, just like every other American has had to do throughout the last 10 or 11 months. So just to reiterate, and I think, Steve, the reason I agreed with you so much when you were talking about this is that I think attorneys, in my experience, have a tendency to sometimes forget that we're not the central focus, that the best interest of the clients always reign supreme, and that they are the main event. And if this virtual world that we've entered creates barriers to those subtle nuances of in-person conversation and interpersonal dynamics, you just have to put a little more emphasis and effort on being able to be there for them and hear what they're saying.
I will say this, I think that during COVID with Zoom and things like that, we can use tools like Zoom to maintain relationships and check in on clients, like both of you are saying. I think it's virtually impossible to get new clients. Not impossible, but pretty tough. You might be able to reinforce existing client relationships. I think it's pretty tough to get new ones. It's hard to build that trust purely through video. I mean, I realize now, like, not that I did it a ton, but like, if you take a client or a prospective client out to a meal or to a game or something like that, boy, you realize, like, yeah, there's some things that you get out of just being in physical proximity that are just not reproducible in this purely video environment.
So I think you've actually just proved the lie to my comment about the virtues of generalism, because you're absolutely right that in this environment, when it comes to picking lawyers and you don't have the face-to-face contact and the sort of genial trust building exercise, what clients are going to look to first is, okay, well, since we're putting personality aside, can't really assess that, how many of these transactions has Stephen Kong done before? And, is he going to be able to anticipate what the other side is offering? And if you've done that transaction, 20 times or 50, then the answer is yes, I can anticipate. I know I've dealt with the lawyer on the other side. I know exactly what he's going to offer. I know how to respond to it. I know how to get you this negotiation. And that's the basis on which they pick. And that's based on specialization. So yes, you're right. Sometimes specialization does win the day.
Yeah.
I guess the last question is, in a time of crisis, why should a person retain legal counsel, and why should it be you? Like, in your firm and practice, what do you offer? What services do you offer people and clients that it would be to their detriment to not consult you?
We are client problem solvers and problem anticipators. So come to us, because if you have an existing problem, we can help you get it resolved. And the chances are that if you operate in a complicated, especially like a complicated regulatory sphere, we will have thought of the problems that you're likely to confront prospectively, and we will be thinking already about solutions before the problems start to impact you. And that's useful. It's an economic benefit to you, and you will be better off having that counseling than if you try to proceed without it.
Yeah, in my world, oftentimes the difficult value proposition for an attorney is that our services are intangible until they're not, right? And difficult to market into a potential suboptimal decision tree or a less than desirable position. But because I spoke earlier about the way that we organized our practice and the way that we operate, and how we break down the fundamentals of our firm, we really seek to attach ourselves to the client and their broader vision and deepen the relationship by being able to kind of anticipate problems, as you just spoke about, Steve. So for us, it's really the flexibility and the way that we're able to price, how we're able to scope work, and the fact that we are really outcome driven as a primary factor. And we're willing to work with clients around what they need and how to get there in a more, behaviorally independent sense, right? Law is difficult at scale with larger firms. And certainly the power users of law firms, like larger companies, aren't really looking for the type of behavioral independence that we can offer. And so we're very self-aware in that respect. But in terms of having some sort of de facto general counsel that's not on payroll, with the ability to be forward-looking, that's sort of our niche, right? Because as much as I've talked about beverage alcohol on this in this symposium, we do just about everything from commercial real estate development to supplier side beverage alcohol work, and that certainly spans the gamut. So our ability to kind of to be front, to lead from the front, and really dive into issues and not necessarily look for legal issues primarily, and be okay with advising in that capacity, has kind of given us a leg up on firms that are just a little bit bigger than us in the short term.
I want to address, one thing. I'm going to take that question and slightly go another direction. In my particular position, being an IP transactional lawyer, the biggest thing that has changed in my field from when I first started doing it was that there are actually very few of us who do it in a law firm. Probably 90% of the lawyers that do what I do, software licensing, IP development, technology alliance agreements, whatever you want to call it, commercial, I call it just commercial agreements involving intellectual property. The vast majority of that work is done in-house today. Apple has more lawyers doing what I do than any law firm by far. The biggest law firm in the country doesn't have anywhere near as many lawyers as an Apple or a Facebook or a Google. Each have doing it. So, you could take your question, Maurice, and ask yourself even more broadly, why go to a law firm? Why don't you just hire a lawyer who works for you full time, and that lawyer will be with the company day in and day out, and they're going to know the products even better, and they're going to know the dynamics, and they're going to work day to day with the salespeople, and they're going to be right in there with the product teams, and they're going to know exactly where the product's going. And the reality of that answer is, like, sometimes it does make sense, but of course the reasons why sometimes it makes sense to go to a law firm are, A, we're either not big enough yet to bring some of that expertise in-house. Although, I spent most of my career in the Bay Area. You'd be surprised at how relatively small and or young a technology company is, and they're already thinking about making their first hires, because it is very hard to replicate the advantages that a lawyer has when they're embedded within a client daily. It's very, very difficult. So then you ask yourself, well, what is it that a law firm then can provide? Why would you come to a law firm then? Assuming you're big enough, assuming you're a relatively big company, in theory, you could hire that person in-house. Well, okay, that puts even more pressure, and this is a mini version of a speech I sometimes give to young associates. That puts even more pressure on you to be very good at your craft, okay? Because they're already paying more, certainly on a per hour basis than if they hired someone to work full time as an employee. That's a tremendous amount of pressure to produce good work product and to really be on top of the law. And then the second thing that a law firm has to be able to provide to justify going to a law firm to solve a legal problem or a problem, let's just say, the one thing law firms can provide is that they work with multiple clients. And so in theory, they should be able to, or not in theory, it's true. they should be able to take the collective wisdom of the lawyers working in that field and say, hey, listen, remember, we saw that client had that issue and that client had that issue, and then try to apply it to the rest of your client base. And so you need to take the one thing that it's definitely a disadvantage, which is you're expensive and you're not there full time with the client. You need to be able to say, okay, well, what are the advantages? Well, the advantages are I work with a variety of clients, and I can see some things ahead of time that may apply to a client who, because they only work in that one industry, they may not necessarily see it because they're very narrowly focused.
I just wanted to add that when I retire from big law, I'm coming to Michael to have him explain his model to me.
Hey, look, we actually often act as intermediaries to folks like you, and that's a niche that we've been able to develop. I've actually resisted employment offers from multiple clients over the last few years, and it's specifically because, to take Mr. Kong's words, we do embed ourselves within the subject matter of the business itself, and we make it a point to understand the widget and or services that are being provided, and how those products and or services make their way to market. And in my world, that takes a lot of time, and where there is not time to be a specialist in any given denomination of law, it just puts the burden on me to know who the specialists are and to be able to quarterback that on behalf of a client when a need presents itself in a manner that exceeds my scope. And litigation is, I guess, the easy categorical answer for me to say, hey, that exceeds my scope. But also, in particular respect, I am not the end all be all to intellectual property issues or even trademark. When there are nuanced trademark issues that bubble to the surface, or the stakes are sufficiently high that I need to bring in someone who has the wherewithal and perhaps the horses in the stable to really dive deep and present an issue, I'm happy to do that. And the clients trust me to make that determination on the front end and not be so selfish as to try and keep that type of work to myself. And I think that actually is the future of sort of the smaller end of the law paradigm. I think there is a big law, small law bridge to be built, because folks in my position are your greatest allies, I believe.
Well, with that, thank you all for those answers, for that question and the other questions. And Mr. Kong, Mr. Boyer, Mr. Hallman, we appreciate your time, and I hope you've enjoyed your time here, because it was very enjoyable for me. And not only that, it was very comprehensive, but most importantly, I think it's be a valuable resource for people who are tuning in. So we really appreciate your time on behalf of the Wake Forest Journal of Business and Intellectual Property Law.
Pleasure to speak
enjoyed
with
it.
you.
Yeah, I enjoyed it very much, and it was great to meet everyone.
Yeah, thank you. Pleasure.